Hello and welcome to the very quick edition of the first chapter of company law, where we'll deal with the meaning and nature of companies. Jumping quickly into it, the definition of a company is not satisfactorily provided in the Companies Act 2013. It simply says in the Companies Act that any company incorporated under this act is a company. So definitely we don't have a sufficient definition from there, so we have to look to other sources to find the definition of a Companies Act. We get these other sources in past judgments, case laws, and other procedures established by law. And these elements that we get help us classify companies. But we'll talk more about types and classification of companies in further chapters. These elements that I'm referring to basically have to deal with the fact that a company is a separate legal person, that it has a common seal, which means that all its branches and all its operations operate under a common name, that it has perpetual succession, which means that the owners and the members of the company, even if they leave or pass away or for any way are not associated with the company goes on. So if Mukesh Ambani, God forbid, should die tomorrow, Reliance would not shut down, it would continue. And that the very nature of a company is that its shares are transferable, which means they can easily be bought and sold by just about anybody really. But perhaps the two most common elements that I would like to focus on is that a company is a separate legal person, which means that it has a separate legal existence, that its liability is also limited, and we'll talk a little more about how liability is limited by shares or by guarantee when we talk about types of companies. But right now, to focus on legal person, when I say a company is a legal person, it means that tomorrow if we incorporate a company, let's say it's called AB Limited, then AB Limited can sue any person that it wants. It means it can file a case. It can have a case filed on it, on AB Limited's name itself. It can do many things that you as a legal person could do. So basically, if you can buy property, then so can a company. If you can file a case on someone, then so can a company. Because anything that a person can do, a company can do, because it has a separate legal existence. And remember that a company is doing this on its own name, not on the owner or the CEO. The owner or the CEO is just acting as an agent, you can say, when they carry out the functions. So a company is absolutely separate from its owner, and we saw this in the Salomon case, where a particular owner had hired all his relatives only to be part of the board of directors. So certain creditors who wanted money from the company, and when the company was short on funds, they said that this person has money, it's all his family only running the business. But it was held that just because a person has a relative in the company, it has nothing to do with the company, because the company itself is a separate legal person. However, there are important exceptions to this, and these exceptions we refer to as lifting of corporate veil. Lifting of corporate veil happens in certain situations when the owners of the company have to be determined to make the company liable. So till now I was saying that the owners and the company are two separate people, they have no joint liability, but there are certain situations where it is important to determine the owner. One such situation happened in England in a company called Continental Tire, where the company was set up in England. So therefore, by what we've learned so far, it was an English person, right? But the owners of the company were from an enemy state. Enemy states are usually states with which a country is at war. For example, the enemy state of India currently would probably be Pakistan. So in this particular case, the owners were from an enemy state. Therefore, the corporate veil was pierced to find out who the owners were and to not give them a separate identity and allow them to set up a company in England. It can also happen in cases where companies are set up for evasion of taxes, when companies are set up for fraud, and when they are simply acting as an agent. We'll talk more about agent companies when we talk about classification and types of companies. Perhaps the most common form of lifting the corporate veil happens through statutory provisions, means that these provisions are in the Companies Act itself. When a company carries on business beyond 6 months, knowing that its minimum membership has fallen below the minimum satisfied in the Act, or when it has a name that misdescribes its operations, it has some name that has to, like AB Pharmaceuticals, but actually the company deals with furniture, for example, or when the purpose of the business was to defraud creditors, it simply is taking money with no intention of creating any value or profit. We see this often with pyramid and Ponzi schemes. Lastly, we'll talk about the registration and incorporation of a company. Today, this has become a very short process, because in the old age, you would have to file a memorandum of association that has fixed clauses, an article of association that deals with the day-to-day operation, and different other forms. However, today you have just one form, INC 32. It's called the Special Proforma for Incorporation of Company, therefore SPICE form. And along with the SPICE form, you will find electronic versions of the MOA and AOA. So 3 forms will help you to incorporate your company. Once you've incorporated, you will get a certificate of incorporation that basically says that you have fulfilled all legal formalities. And after that, you will need to require a certificate of commencement of business within 6 months to start commencing your operations. Commencement of business basically means that minimum subscription of your issued capital has been subscribed to, that there are directors have paid their money, certain legal formalities that you will see and we'll cover in further chapters. Thanks for